Welcome to the courtroom, where justice meets drama. Today, a mother of one, held for over 90 days, fights not just for bond, but for her freedom. With the law on her side, and the state pushing back hard, the tension is real. This is one hearing you don't want to miss. Let's break it down.
Court is calling 2025 PF 03974, 2025 PF 03973, 2025 PF 03972, 2025 PF 03971, 2025 PF 03970, 2025 PF 03969, State versus Valerie Campion. Could I have parties announce?
Matthew Allen for Miss Campion.
And are you Miss Campion?
Yes, ma'am.
All right, in each of these cause numbers, the defense has filed a motion for a PR bond. State, have you had a chance to review the motions?
I've not reviewed the motions. I've reviewed the cases, specifically the pre-filed cases.
All right.
As I understand it, that was what Alan sought reduction of bond for.
He's asking for a PR bond.
Since the indicted cases are indicted, and 17.151 is inapplicable for those. And in addition, as far as I can tell, Ms. Campion did make bond on those cases, and bonds have not been revoked subsequent to arrears. But please correct me if I'm wrong.
All right, so here's my question. He's asking for a PR bond in those cause numbers that I've called out. Are you in agreement to the PR bond? Or are you citing another rule that says she's not entitled to a PR bond even though the cases have not been indicted?
She's not entitled to a PR bond because 17.151 gives the courts.
I know, to reduce bond or a bond she can make or either a PR bond, but my question is, are you in agreement with the defense for her to have a PR bond?
No.
All right, so the answer to that is no. So do you want to present any evidence? Well, before you present your evidence, you are in agreement that she has not been indicted within the 90 days.
Correct.
All right, you want to present your evidence?
Yes, Judge. I would call Miss Campion for the purpose of the bond reduction / PR bond.
All right, could you raise your right hand for me? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Valerie Campion.
All right, state, you may proceed.
Oh, if the defense, I called.
I'm
her.
sorry.
That's
defense.
okay.
That's
I just wanna make
okay.
sure.
I'm used to you being,
I know.
I remember when you were on the other side, but go ahead.
Okay, so the Miss Campion, you're the defendant in the cause numbers that were listed, right?
Yes.
Okay. Tell me about, when did you move to San Antonio?
When I was size
All right, how old are you now?
35.
And have you lived in San Antonio that entire time?
Yes.
What family and friends do you have in San Antonio?
My mom and my stepfather, I have a 15-year-old son. I have 6 sisters, 3 brothers, my dad, my stepmom, and my 2 little brothers on my dad's side.
Okay, so you have a very strong ties. And you would, if and when you bond out, you'd be living in San Antonio?
Yes.
Okay. You've been in continuous custody on those cases for 90 plus days, is that right?
Yes, sir.
Obviously, you haven't been able to make any money during that time.
No, sir.
How much money do you personally have either saved up or able to get through assets, selling assets, financing assets? How much total do you have to be able to put towards all the bonds for not just these cases, but your indicted cases?
I have $2,000.
$2,000. Okay. And again, that includes all of any assets that you have a part of and things like that.
Yes, sir.
Okay. You've spoken to your family since you've been in custody.
Yes, sir.
And how much money, same question, through assets and everything combined, do they have to be able?
$1,000.
Okay, and so total you have $3,000. On your indicted cases, the bonds total about, I believe, 35,000. Is that right? Okay. Has your family contacted bond companies?
Multiple.
Okay, and they have not been able to bond you out on these cases?
Correct.
If you were released, would you remain living in San Antonio? Would you follow every condition that the bond that the court put in front of you?
Yes, sir.
Do you believe that, and you said you have a child, do you believe that you'd be able to be employed once you got out?
Yes, sir.
Okay. Do you have a job waiting, or you think you'd be able to get a job?
Well, I had a job before, so I don't know if I still am employed, but being that I haven't been convicted of anything else, I believe they'll allow me to come back to work.
Okay, but even if you don't get that job, you believe you'd be able to stay
Yes.
employed? All right. Okay, I'll pass the witness.
Any questions?
From the state judge.
All right. This is what the court going to do in each of those cause number. The court is setting the bond at $3,000. There's going to be partial GPS for employment, waived GPS fees, and there should be no unsupervised contact with minors. And there's to be regular UAs. All right. Now, with regards to the other cases that have been indicted, counsel, where are you on discovery?
Judge, I believe I've received the discovery in those cases. I just have not had an opportunity to review all of it.
All right, Ms. Ferguson, recall this. I need a 30-day reset. All right, we're going to come back on June 10th. State at that time, you'll need to be prepared to tender an offer.
Yes, sir.
Thank you, Your Honor.
Thank you.
Thank you.
And there you have it. In a dramatic turn inside this Texas courtroom, Valerie Campion just fought for her freedom. Her defense team pushed hard for a PR bond, citing Texas Code of Criminal Procedure 17.151. A legal lifeline for defendants held more than 90 days without indictment. But here's the twist. While the state acknowledged that the 90-day window had passed, they still objected to a personal recognizance bond. Why? Because Valerie had already made bond on some charges, and PR eligibility becomes murky once prior bonds exist. The court, not swayed by the state's objections. After a compelling testimony from Valerie, where we learned she's a lifelong San Antonio resident with deep family roots, a 15-year-old son, and no ability to post the $35,000 bond, the judge showed leniency. He ruled in favor of reducing the bond to $3,000 per case, with GPS monitoring for employment, mandatory drug testing, and, notably, no unsupervised contact with minors. This ruling walks a fine line between protecting public interest and upholding a defendant's constitutional right to bail. It also raises real questions about our justice system. Is it fair to keep someone locked up solely because they can't afford bond? And more importantly, did the court strike the right balance here? The next hearing is set for June 10th, where both sides are expected to move forward with discovery reviewed and plea deals potentially on the table. What do you think? Was justice served in this case? Should Valerie have been granted a full PR bond? Drop your thoughts in the comments. We want to hear from you. If you found this courtroom showdown as gripping as we did, don't forget to hit that like button, subscribe for more high-stakes legal drama, and share this video with someone who loves a good legal twist. Until next time, stay sharp, stay curious, and we'll see you back in court.